Welcome back to Ask the Attorneys. Today's topic is how do trusts protect you while you're alive? And once again, I'm joined by attorney Matthew Underwood to discuss this topic. And Matt, I think a lot of times, I know I'm guilty of this in my own practice, but many clients, when they come in, they've heard somewhere that a trust is a good idea to avoid probate upon death, right? And I skip over, or they skip over, or we both skip over thinking about the other benefits of a trust, which is how it can protect you during your life. So today I thought we'd talk about that. And I wanted to hear some of your thoughts on this aspect of trust planning.
Yeah, that's a great point, Tom, because when we think about estate planning, whether it's a lot of attorneys or even clients, you think about death, and really that's what we're planning for. But it is lifetime planning as well. And we want your estate plan to protect you while you're alive and well, and if you were to pass away. So we don't want to leave any stone unturned there. But I would say, just to kind of give an example, let's say somebody, they don't have an estate plan in place, they don't have a trust set up, and they get into a car accident, and now they're in the hospital, and they're kind of out, and they can't really manage anything anymore. They're recovering in the hospital. So what happens now? Well, if you don't have planning in place, those bills still have to get paid. Whether it's the mortgage or, you got other obligations out there, those don't stop. Those still need to be taken care of. The house still needs to be maintained, whatever it might be. Maybe even you have younger kids at home, and they need to be taken care of. So, with planning, for example, we can avoid that uncertainty. And in specifically, we can avoid having to go through guardianship. So guardianship is a court process where if somebody doesn't have their own estate plan in place, family has to go to court and basically ask a judge for permission to handle issues for that person who's incapacitated. So by setting up a trust, the person can specify a successor trustee, and the successor trustee would step in whenever that primary person is incapacitated. And then the successor trustee can step into that person's shoes and pay the bills, or do whatever sort of management things that person would do normally. So whether we're choosing to do no planning and saying we're going to go the guardianship route, that typically means more uncertainty, more costs involved, greater time involved before we can get that judge's order, versus doing a trust where we know as soon as we sign that trust and it's notarized, now that person's protected. And if anything happens, that successor trustee can step in and handle things. So I think, avoiding those court processes, avoiding court cases, we want to do that through trust planning and make sure that we're picking people to handle things without having to go to a judge and get extra permission. Would you say that's one of the things that you see in your practice, Tom, when we're talking about trust, people see that as an advantage?
Yes, well, I think it's part of the education we need to do about really what advantage they provide during life, because
Mhm.
people are living longer, and I'm seeing more and more clients fall into this area where they're alive but may have incapacity issues. They're not dead, because when you're dead, you're clearly, that part is over, and then the trust takes over the distribution of assets. But the part while you're alive, you need to look out for your own health and welfare. And that's where you need someone using your own assets on your behalf as a fiduciary. Um, and we are even seeing where people can go, you can have a period of incapacity that you recover from, like a serious illness. Then you get better and live a lot more years after that. So you still need those assets for your own care. It's not like when you're gone and you don't need them at all. But what I see is, if people don't do the pre planning, unfortunately, some people think they'll have time, whatever that is in the future, to do it. But I had a case this spring where the family came in, husband and wife. Unfortunately, the wife got a cancer diagnosis, and by the time they scheduled the meeting, but by the time they got into the office, she had already declined and was in the hospital. And they were talking about a guardianship for her, because I had to have a discussion with them about whether we talked about drafting some documents, but the question was, would she even have capacity to sign the document at that point? Because uh, due to the cancer treatment, she was on heavy medications, and which caused, you know, when you're alive and healthy outside the hospital, it's a lot better time to be executing legal documents, because unfortunately her diagnosis came and it progressed so fast that it seemed unlikely she would have the requisite legal capacity to even execute documents at that point in time, even if we could get them done that quickly. So I recall they were sitting in the conference room and talking about a guardianship, because the hospital had brought up the need for a guardianship, because she didn't even have a healthcare power of attorney in place either to make medical decisions. So no documents at all. But what I'm getting to here is the talk about the guardianship. Uh, I don't think people quite understand how involved a process that is. Like you said, it's a court process, and you have to think of it similar to going to court about anything else. Uh, it isn't a simple submit a form to the medical provider and you get awarded a guardianship. You have to have a hearing, and the judge has to go through the factors under the law to decide if they even should award this guardianship to the person petitioning. So what I'm trying to say is the reason why Matt pointed out it can get expensive fast is because all that involves paying attorneys to bill hourly to go to court and get the guardianship awarded. And then the person who's the subject of the guardianship proceeding, they're entitled to be represented by their own attorney. Uh, so, and that's to protect their constitutional rights, right? But I just think what I see in my practice is the term guardianship is sometimes thrown around, but people don't really understand that it's not something you can just get done overnight generally. Would you agree with that, Matt?
Yeah, that's a great point. And even, what you said about delaying planning, I think, if we had that proverbial nickel every time somebody said that, I'll get to that later. Next year I'll do my estate planning. The fact is we don't know when things are going to happen. And, I think it's more likely that somebody will be faced with a situation where they're incapacitated before
Yes.
they, are faced with death. I mean, it's more likely that the family's going to have to deal with the incapacity situation. So we need to do a really good job about planning for that. Because again, we don't know when things are going to happen. And, a lot of times people delay things so long that now we're at the point, like in your example, Tom, where, well, maybe we're too late to do that planning. And now we're forced to use the court system to get things done. So getting people to do the planning and actually invest the time and do it now rather than delaying it, I think is really valuable. But it's sometimes hard to convince people to do that when you think of incapacity or you think of passing away as something way off in the future. And they're not the most pleasant conversations to have. I mean, it's something that we have to do. We don't like talking about being incapacitated or passing away, but it's so important. It's such an important thing that you can do for your family and to make things easy for them, to make sure that we're avoiding disagreements, and make sure that people know what the plan is and then who's implementing that plan. So I'd say that's a big benefit. And the other one that we didn't talk about yet is just getting things organized. A trust is one way where we can pull assets together. So for example, we can set up a trust, we can put the house in the trust, real estate, vacation property, we can put the bank accounts in the trust, we can name trust as beneficiary on life insurance. So the trust really becomes a centerpiece for that plan, and it now becomes our one-stop shop where if we need to deal with assets, they're in the trust, they're
Mhm.
consolidated, they're organized. And so that's a really nice thing we can do for our clients. And when we set up a trust and when we fund that trust, or if we get those assets into the trust, it's great seeing that sigh of relief over our clients, knowing, with them knowing that they're set up and they're protected. So yeah, for those reasons, I think, for putting a will plan and a trust plan side by side, I think, if those two plans cost the same, everyone's going to do a trust. But the fact is, trusts tend to cost more, so that, cost might be a factor in this. But again, to get the best planning, oftentimes that means we're looking at trust-based planning for people.
Yeah, the one vehicle concept, everything flowing through that one trust is really key, and something I find really appeals to clients, because with modern life, where many of us, you can have multiple brokerage accounts, bank accounts, uh, the house, real estate, a cabin, cars, you know, having one vehicle that can handle it all, and you can give your family the one document that is the plan for everything, is very beneficial. Because even if there's other ways to do it piece by piece, uh, I see a lot of confusion when people come in with plans like that. And I had a client this summer who they said, I just want everything to be laid out, through this one document for my family. And I think that's another big benefit. You can go to the trust document. Now, Matt and I know we can't usually make a trust 2 pages, right? Because I like to say the trust is flexible. We try to make them flexible to accommodate all these different assets and scenarios. So it's generally going to be a little longer than a simple will, for example. But then the beauty of it is we can use it for all of those assets and build in some of that flexibility for planning over your lifetime. And I think, like I said, just making it less complex and confusing for your family, or whoever's left, the surviving spouse, the family, is another big benefit to your family and to the way a trust can protect you during life and after death.
Yeah, exactly, Tom. I would say, the people that we've helped in our office, and I'm guessing you would say this too. I mean, there's a certain amount of pride that you feel when, you put a lot of thought and effort into doing your own estate planning, and now you get it set up. All your wishes are in there. It's properly signed and executed. And now your assets are in that trust. I think that's a good source of pride to know that you did everything that you need to do to protect yourself and your family. And so I think, that's one of the best parts of my job, is when we get a completed plan, and having that sense of pride and relief to our clients, knowing that everything's set up and taken care of. It's one of the nice parts about our job and the planning that we do for people.
Totally agree. Well, thank you, Matt, for joining us.
Yep, thank you, Tom. It's always a pleasure to talk about these topics, and they're really important. So I'm glad that you're another expert in estate planning that we can discuss these issues with.
And thanks to everyone for tuning in to Ask the Attorneys. We'll see you on the next episode.